The distribution of property in accordance with the descendant's will or trust can be a straightforward matter, or it can prove to be a trying event for the family. Joining us by phone to discuss what happens when the legal doctrine of ademption is invoked is Kansas Farm Bureau Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen. Thanks so much for joining us, Roger. And let's start with an example. What happens if a parent dies and specifies in a will or trust that a particular family member is to get a specific item of property and it doesn't exist at the time of death?
Well, good morning, Christina. This is a big issue in agriculture as well as many other non-agricultural estates, too, because a lot of times parents like to identify specific items of property and tell the specific person that's going to get that. Well, when that specific item doesn't exist at death, it is said to have been deemed. And there are two ways that can occur. Maybe it was gifted away, or maybe it was sold, or however it occurred. What happens when that event happens? Well, that's an issue that many people need to think about when they are leaving specific items of property to their heirs.
Oh, certainly. And that's one of those things. How can you actually avoid that? Because you never know what's going to happen when you're writing your will or trust.
Well, you really have to give some thought. At least the drafter of the will or the trust has to give some thought as to the language that's used to describe specific items of property. And if there are specific bequests, and I'm not saying it's a bad idea to do that. It actually can be a pretty good idea. You need to think through where you want that, how you want that will or trust to read in the event that property is no longer there. Does it go to a residuary part of the estate? If so, are there going to be multiple takers to the residuary property? It really needs to be thought through. This is one of the reasons why we say don't do wills on your own. Get some professional help.
Yeah, I'm sure that that's something that you recommend and something that you deal with quite often in your field. What exactly is ademption? Can you give us an overview of that legal term?
Yeah, again, it's just when the property that is specifically devised no longer exists. And one of the areas we see it in agriculture, and we just had a case on this that came up in Iowa, is that the parties, after Dad died, they had created a revocable trust, so everything went to Mom. And Mom did a like-kind exchange of one tract of farmland for a different tract of farmland. However, the tract that was exchanged was specifically described by legal description in the will to go to a particular son. Well, after Mom's death, that specific tract no longer existed. It had been replaced by a different tract in a tax-deferred exchange, but it wasn't the specifically identified tract. So the problem was it ended up in the residuary estate. That brother ends up owning it with his brother, and now you got co-ownership issues and probably down the road a forced sale. Not a good result.
No, and a problem that could have been avoided with very precise language, like you pointed out. Thank you so much for your time. We always appreciate your thoughts. Kansas Farm Bureau Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen. Thanks for joining us today.